Okay, I'm here with Leducate today to talk about the Constitution. So my name's Alison Pickup, I'm a barrister and I'm the legal director of the Public Law Project, which is a national legal charity that promotes access to public law remedies. What do I mean by public law? I mean the law that governs our interactions with the state and the rules that govern how the government can make decisions about us that affect us, often in our everyday lives, sometimes at a more theoretical or constitutional level. So I've got some questions to answer. First question, what is a constitution? A constitution is broadly, well, there isn't really a universally accepted definition of a constitution, but it's basically a power map. It's the rules that describe who can exercise state power and how it can be exercised, and which put limits on the exercise of that power. Before I go on to answer the other questions, it might be helpful if I talk about some of the key concepts or terms that I'll be using while answering the other questions, just to explain what I mean by that. First of all, I'm going to talk about parliamentary sovereignty. And by that I mean the idea that Parliament has complete power to make any laws that it wants, and it's sort of the senior partner in the Constitution. Related to that is the concept of separation of powers, by which we usually mean the distinction between three different parts of government. So we've got Parliament on the one hand, secondly the executive, by which we mean the government essentially, and thirdly the courts. And it's an important part of our constitutional makeup that they're separate. In terms of the executive, which I mentioned just then, as I say, by that we mean the government. In the UK, the executive is made up of members of Parliament, so normally the party with the biggest majority in Parliament appoints the leader of that party becomes the Prime Minister, and he'll then appoint ministers to the Cabinet and more junior ministers drawn from the MPs, generally speaking, those elected to Parliament. Second question, why are constitutions important? Well, they're important. Constitutional theory identifies two main reasons why they're important. One, because they give those who exercise power democratic legitimacy. So they identify who will be able to exercise that power and who is politically and democratically constitutionally allowed to exercise it. And secondly, they're important from the perspective of the rule of law, because they put limits on the exercise of that power. So they say when it can and when it can't be exercised, and set at least some principles to govern the exercise of power. So that's why they're important. Question 3, going through these quickly. How do they become law? Well, that is different in different countries. So in some countries, like France or the United States, constitutions were adopted after a civil war or revolution. So those old countries had what we call a constitutional moment, where they adopted a written or codified constitution in one place. So in the US, for example, in the 1780s, a constitutional convention got together. People drew up what they thought would be a good codified constitution to govern the way power would work in the US, the way the new government would work. And then that constitution that they drew up was then ratified by conventions or referenda, if you like, in different states around the United States, and then it was approved by Congress. And because it's been through that process, any changes that are made to the Constitution then have to be approved by a particularly high majority of members of Congress. In the UK, we never had that kind of constitutional moment. Our constitution has developed over the centuries through a process of decisions. There's some acts of parliament, there's court decisions, different ways like that. It's developed and it's been kind of discovered over the centuries. So, question 5. Would the UK be better served having a codified constitution? That is a question which has a lot of different answers and is a subject of great debate. So some people think that a codified constitution is better because it gives you certainty and it gives you one place to look when you want to know what constitutional principles are. On the other hand, people would say that having an unwritten constitution gives greater flexibility and allows the constitution to evolve as social norms change, as things develop in the community as well. So there's a debate about that, and there is definitely room for lots of different legitimate views on whether we'd be better with a codified constitution. So the next question, what makes our constitution different to other international constitutions? Well, for starters, as I've said, it's not written. We don't have a single codified constitution in one place. Like in the United States or in France, there's a particular document you can go to called a constitution. And the second key difference, what's unusual about it, is the importance which our constitution puts on parliamentary sovereignty. So in theory, in our constitutional arrangements, Parliament is completely sovereign and it can make or unmake any laws. There's a bit of debate about how far Parliament could go, but in theory there are no legal limits on what Parliament could enact in an act of Parliament. There are obviously political limits because parliamentarians want to be re-elected, so they're not going to do something that would be hugely unpopular with their constituents. But because Parliament can make or unmake any law, and because we don't have a codified constitution in one place, that means that it's relatively easy for our constitution to be changed by Parliament. So if Parliament decided to change some aspect of our constitution, it could enact an act of Parliament to give effect to that, and that would be passed by a simple majority, so just more than 50% of the MPs and the peers in the House of Lords could pass an act of Parliament that changed our constitution. An example might be said to be, for example, the Human Rights Act or the legislation around our withdrawal from the EU, are all changes that will affect our constitution are made by acts of Parliament. In contrast, in countries with codified constitutions, there's generally a much more involved process requiring more than just a simple majority. So, for example, 2/3 of members of one of the elected houses, sometimes ratification by individual states, before a constitution can be changed. The other thing that's particularly significant about the fact that it's neither written, neither codified in one place, and the parliamentary sovereignty aspect, I suppose, is that there isn't a clear definition of what is a constitutional law. So, as I said, I think that few would argue that the Human Rights Act is a constitutional statute, which is part of our constitution. For example, what about rules about who can vote or about electoral boundaries? Are they part of our constitution? Are they constitutional laws? Because we don't have a written constitution in one place, it's quite hard to answer that question. So room for debate. Contrast that again, say, to the position in the United States, where debates around, for example, gun laws are constitutional because the US Constitution protects the right to bear arms. And so those are clearly constitutional issues in the United States. In this country, we would think gun laws are just a political question, like how much control do we have over gun possession. So that's a couple of ways in which our constitution is different from other constitutions. So the next question is, what is the status of the Human Rights Act 1998 now that EU legislation is on its way out? Well, the first thing to say is that the Human Rights Act is a piece of domestic legislation that gives domestic effect to the European Convention on Human Rights. We have what's called a dualist constitution, which means that when the UK signs up to international treaties, they have no legal effect in domestic law unless they are adopted and incorporated through domestic legislation, generally speaking. So the Human Rights Act was adopted by the Labour government in 1998 in order to give the European Convention on Human Rights domestic effect in the UK. The European Convention on Human Rights is an instrument of the Council of Europe, which is not the same as the European Union. The Council of Europe is much bigger. It has member states, for example, such as Russia and Turkey, who are not members of the European Union. And whether our leaving the European Union doesn't mean have any effect really on our membership of the European Convention on Human Rights. However, the European Union does expect all member states to be members of the European Convention on Human Rights and to sign up to it. And also the EU Treaty adopts the human rights as protected by the European Convention on Human Rights as fundamental principles of European Union law. So for as long as we were part of the EU, although it's a separate institution, it was necessary for us to keep the Human Rights Act and to be involved, to retain the European Convention on Human Rights. In the political declaration on the future relationship between the UK and the EU, the UK gave a commitment, that's a political declaration that was agreed as part of the process of withdrawing from the EU. The UK gave a commitment to continue to comply with the principles and the framework of the ECHR. So there is a kind of commitment that we've made politically to the EU that we will continue to comply with the ECHR. And the other thing I would say, though, is that in the 2019 manifesto, the Conservative Party obviously won the election, gave a commitment to update the Human Rights Act. So we don't know yet what that's going to look like or what that might mean, but there is an indication that they may make changes to the Human Rights Act, which may be on their way. Finally, what would taking back control of our laws actually mean in terms of the Constitution and Brexit? Well, I think taking back control in this context could mean different things to different people. Leaving the EU obviously means that EU law will cease to directly apply eventually after the end of the transition period. And it could be an opportunity for strengthening the parliamentary sovereignty and Parliament's role, and allowing more time and more thought to be given to enacting our own domestic laws. Or it could also mean increasing concentration of power in the executive, potentially welcoming government ministers, potentially deregulation, which might be considered regressive by some people.